Joining me now to break all this down, Miguel Custodio and Bob Bianchi. Thank you both for being with me. What a day. 3 days to get to a guilty verdict on the highest count, the manslaughter. What are your thoughts, Miguel?
Well, I'm surprised that it took the jury this long. Based on all the evidence that was presented, it didn't seem like there was any other person to blame. She was the only one, and she had 4 children that she was caring for. There was nobody else that they could blame, and so they came to the reasonable conclusion.
I think so too, and Bob, that's what I wanted to talk to you about. There was no one else to blame. She had the baby. The levels of the baby were this amount. They were more than twice the lethal dose. Nobody was there within the time frame that there was testimony it would have taken for that to kill an infant. What are your thoughts about this verdict?
One of the difficult things, Judge, when you're assessing these cases, and I think we've talked about this for many years, is that we never get an insight into what the plea offer in the case was. So we don't know what the prosecution was offering. Sometimes they make an offer. I did this in many murder cases where I'm like, I'm not going to plea bargain a murder case. You either plead to the indictment or you go to trial. Under those circumstances, the defense is forced to go to trial with the hope that maybe somehow I can convince one of 12 people to feel bad for her and hang the jury. I don't think that they were expecting an acquittal. So I think that that is what is at play here. 7 hours does not overwhelm me in terms of jury deliberations. I got to go in. They've never done it before. They want to give the defendant a fair opportunity. They're meeting for the first time and discussing the case for the first time. So the timing doesn't surprise me. But I think that the defense was put in this position. Last point, I got to be honest with you. As a homicide prosecutor, these kind of cases broke my heart. They really did. I mean, a young baby is dead, but by the same token also, and don't call me a softie, Judge, it just is the way it is. This woman did not wake up that day with the intention of killing this baby. Obviously, if she did, she'd be charged with a higher offense. And now her life and her family's life is ruined too. It's just a terrible tragedy all around.
It is, and I would agree with you. That's why it's a conviction for manslaughter, a neglectful act. She probably thought, oh, I'm going to calm the baby down and give the baby something she should never have given the baby. That, I think, is what happened. Now, the jury has been excused, and the judge and the attorneys are back on the record, so let's go back inside court. Well, this is an unexpected bombshell. Miguel, Bob, still with me. Let me start with Bob, former head prosecutor. As you hear that, hey, hold the phone, we have a verdict, but now there's more evidence. The state's just provided that they've just received, number one, that mom, who was a witness, was co-sleeping with the baby. Co-sleeping causes babies' deaths every single year. I could tell you all about that. It's not a good thing. But number two, the other was, hey, there's evidence that there was a witness who gave documents saying mother need mental health treatment. So they're saying credibility of the mother, that witness is out the window. We want a new trial. Bob, talk to us.
Oh, boy, Judge. You know, listen, this is going to come down to an evidentiary hearing, and we're going to have to make a determination, or the court's going to have to make a determination as to whether or not the failure to disclose this information was done willfully by the government. And if, in fact, that is true, you are exactly correct. The defense was entitled to have this information to impair the credibility of the mother, who is a crucial witness in this case. I say this all the time, doing this legal analyzing on court TV and, you know, other places where it's not just enough to win a case. You have to sustain it through appeal as well. And when you see sloppiness like this, and again, I'm not going to point the finger. I don't know when the government became aware of this, but if there were records in the possession of the government, and she also said, the prosecutor, may I add, I have other stuff that has yet to be disclosed, I have to ask, why don't you do this? As a prosecutor, before you try a case, you make sure the defense has all of the information so this very thing does not happen. Last point, Judge. Why did the defense not argue this in the bail motion? They could have argued that this gives a reason that there could be a sustainable and substantial appellate issue, and therefore she should be released. It's just a shame all the way around.
Yeah, we're getting to the point of the investigation when they are detailing the scratches on his arms, Bob, etc. Just a reminder for all the viewers, he's facing 10 counts, 4 different types of murder charges, 2 aggravated charges, 1 kidnapping, obstructing a 911 call, tampering with evidence, and peeping Tom. Why do you think, Bob, that he chose a bench trial?
Huge mistake, Judge. I, for the life of me, cannot understand why a defense attorney would go before 1 rather than 12. You always may have some aberrant juror. You never know. As a prosecutor, I always worry, did I pick one, excuse the expression, kook, who's on this jury? Now, for these people who are thinking that the judge is going to somehow be fairer, this judge is an elected official. As you are noting, this evidence is substantial. Now the defense has taken away all the sizzle, all the smoke and mirrors, all the calls to emotionality that you can bring to a jury. You can't do that with a judge. And here's another point, Your Honor, Judge Ashley. Here's the other point. On an appeal, should there have been some evidence that was admitted that was improper, it's going to be viewed in a different standard. They're going to say that the judge, because he's an official of the court, had an ability to be able to look beyond the prejudice of that admission of that evidence, as opposed to a jury that's a lay group of people. For the life of me, it's almost like they're throwing their hands up and giving up unless there is some super duper, super crazy thing we don't know about that is a technical violation of the law that they believe only a judge could deal with as opposed to a jury. Makes no sense to me.
This is a good time to bring in our guest for this hour. Still with us on the program, joining us, criminal defense attorney and former head prosecutor Bob Bianchi. I really appreciate the fact that the prosecutors are very meticulous in this. I mean, they're showing the judge who's rendering the decision in this. This is a bench trial, so they're showing him things like the rock, piece of the branches, and then they did that demonstration with the tape measure. I think it's really effective even for a case that's before the judge, but I'm not sure if they proved their point with hindering the 911 call.
Yeah, I mean, I don't know if they proved their point. Yeah, we have to listen to a lot more evidence that comes in here. But you know what the prosecutors don't care about this. Like, as far as I'm concerned, they've made it so easy for the prosecution to present this case to a judge. All they've got to do is not fumble the ball. And let's talk about what we didn't hear on cross-examination. One of the areas that you could have a problem when you're talking about DNA evidence, blood evidence, things of that nature is the manner in which it's collected, or whether there's cross-contamination that would put the results to be suspect that would occur at the lab. We did not hear anything with respect to that. So I personally think the defense has nowhere to go with this. They're not going to be able to win any emotionality with this judge who's an elected official in that town. They've lost the opportunity to make appeals to 12 people. They only have to convince one person now, the prosecutor. So all the prosecutors have to do now is just make sure they get all the evidence in. They have the lab technician tell you what the results of that evidence are, and they have DNA, they got fingerprint evidence. This is going to head it steamrolling to a guilty verdict.
But Bob, I wonder if it's going to be a guilty verdict, and if the defense felt like that's going to happen regardless of who hears this case, perhaps they want the judge to do the sentencing. Perhaps they want all this evidence out there for him to take that into account if there's a conviction. I don't know. That's just something that may make a difference. To your point, the friend testified when she was out looking and found the earpod. She picked up the earpod. Of course she did. I would too. But the point is, they didn't bring that up on cross-examination or make a big point about it. Here's what I want to ask you, though. It's only been 9 months since this happened. This happened in February of this year. 9 months is pretty speedy to get to a trial with 10 counts, including 4 different murder charges. And Bob, the reality is it's a lot easier to have a great witness 9 months because they remember everything. This agent remembers, oh, the rocks were on top of the leaves. Every detail she seems to remember.
Yeah, she's really a great witness. Listen, we've all been here. We've all seen people who are very skilled, but they get on a witness stand and they just fall apart. They're just not good witnesses. This is a very methodical person. She was answering the questions appropriately. And of course, let's not forget, there wasn't really a very aggressive cross-examination. In all likelihood, I'm going to have to presume, because they dotted I's and crossed T's. Judge, I have prosecuted homicide cases where the collection of evidence was so sloppy, so poorly done, that I just sat there and the defense was question after question putting a dagger in my heart because they were correct when they were bringing up all of the mistakes that they made in the collection of the evidence. You don't find that with this witness. So not only was she great at the technological aspect of what she did and how she did her job, but she was also a great witness in terms of how she communicated it to the court.
I agree.
Well, to your point, it's just fascinating that this is one of those cases that gets streamlined within within a few months of going to trial. And a lot of the cases that we cover here on Court TV, yes, with COVID was an issue, but they are years later. That they are adjudicated. Still with us, criminal defense attorney, former prosecutor Bob Bianchi, watching along with you at home. Bob, so something stood out to me, though. And maybe it stood out to you as well. The collection of evidence. Yes, we have the body camera video, but is it normal that the PD sees key evidence in the case and they collect it themselves, throwing over the bag, rather than having the GBI come out and have crime scene tape and have, you know, it processed in that way? Is that something that could be challenged?
Yeah, it can be, but we have to be practical. If you've ever responded to something like this, I can assure you that there's a command center somewhere, and there are so many moving pieces that are going on during an investigation. Actually, I'm extremely impressed by how these officers knew to go to dumpsters. I've had multiple cases, believe it or not, where evidence is dumped off, and they don't go into the dumpsters, and now we're trying to track down where the trash went. So these guys are jumping on it, but sometimes you don't have the resources to be able to send everybody out to collect it necessarily the way you want it. So you put it on body cam. They were wearing gloves. They're literally announcing what it is they're finding. I see no problem with that from an evidentiary standpoint. And I got to say one last point here. I'm really heartened in how the officers did the canvassing to find this crucial evidence. But I really love the cadence of the prosecutor with her witnesses. These are very prepared witnesses, and it's like watching a well-orchestrated dance. It's not choppy. It's not all over the place. She is just killing it by putting in one piece, building it one block on top of another. I love watching it.
Yeah, she knows exactly how to try a case because she knows what she has to ask to get it into evidence and to proceed with her case. So, Bob, one other thing I want to mention. I mean, clearly they were just testifying they'd looked in other dumpsters. In addition, you could tell by the expletive and surprise when they actually saw something and saw dark hair and buttons that they realized, wow, there may be evidence. Because I think what we have to remember about investigations is at the trial, we hear about what led to this defendant, but that means they've gone through loads of other evidence that really has no significance whatsoever and narrowed it down. Exactly.
Yeah, Judge, I mean, the last homicide case I tried as a prosecutor probably had 10,000 pieces of evidence. And sometimes this becomes challenging because something may be benign and you don't even understand the relevance. It literally happened to me with a knife rivet, believe it or not, in a case. And it wasn't until the defendant took the stand that knife rivet became something like I remembered it in our evidence log. So it's really challenging sometimes. When I first started trying cases, we never had forensics like this. We didn't have phones. We didn't have electronic data. We didn't have DNA. We didn't have the ability to process crime scene like this, but now we do. So they're doing a great job, Judge.
All right. Thank you so much, Bob Bianchi, for always being with us.
Still ahead.